everyone. Thank you so much for joining us today with the Vicente team. My name is Anne with Dutchie. We've got a great session for you today on preparing for New York cannabis licensing. We have a lot of amazing content to go through. I'm sure all of us attending and listening have a lot of questions. I sure have a lot of questions coming out of that CCB meeting a few days ago. If at any point during the session you do have questions, feel free to drop it in the chat or in the Q&A section of the Zoom call just at the bottom of your screen here. And we will try to answer as many questions as we can at the end of the presentation. With that being said, we have a lot of great content, so I will hand this off to Michelle from Vicente to kick us off. Thanks all.
Thanks so much. We can just do quick introductions and then we can dive in. I'm Michelle Bodian, a partner with our New York office. I've been helping people do licensing and regulatory work in New York for several years now. Pretty excited. We're about to open it up a bit more. And then Brandon, Elliot, if you want to introduce yourself as well.
I'm Brandon Kurtzman. I'm a partner in Vicente's New York office. Been with the firm for a long time now, and been focused on New York for the past couple of years. So very excited that we finally have licensing opening up, and we're going to get to apply for some more licenses.
Hey everyone, I'm Elliot Choi. I know we had advertised this with Charlie Alvacetti, but unfortunately he couldn't make it, so I'm a last minute swap in. Sorry to disappoint the Charlie fans out there. I'm a corporate counsel and chief knowledge officer here at Vicente, so I handle the kind of the corporate side of all the licensing work here. I'm also a New York resident, grew up on Long Island, so I'm pretty excited to finally have a New York industry to advise on. Although obviously the rollout hasn't been kind of as is hoped, but you know, we'll get into some of that on this webinar.
All right, yeah. Let's get going. As it said in the invite that brought you here today, we're going to cover a brief timeline of the market, just kind of talk about how we got here, you know, get that out of the way first to talk about where we are today and where this is going. We're going to get into a little bit more details on the applications. We're going to focus today mostly on the adult use application, but medical and research are available as well coming up for licensing, but this will be kind of adult use focused. Stay tuned for future webinars on those other topics. And then raising capital, which is diving into a lot of the true party of interest. We're going to try to spell out all of our acronyms, but you're going to be hearing TPI a lot. Then as Anne said, we'll be leaving time for questions and answers at the end, but definitely feel free to kind of pop them in the chat as they pop into your head, and we'll do our best to answer them, but we also have a lot of questions. So some of this we might need to stay tuned for more information from the state, which should hopefully be coming soon. All right, with that, let's dive into how we got here. Try not to bore you with all the details, but just put together this kind of helpful timeline, what we think is helpful of how we got here. Just a reminder, kind of some key dates here, you know, March 2021 MRTA. So we're looking at, you know, coming up on not too long for another anniversary here of where things stand. And then just talking about some of the funds that have been announced and potentially available. And then, you know, a little bit of the litigation history, kind of hard to talk about New York without mentioning some of the litigation. Next slide. But, you know, notably here with some of the litigation, I'll get into a little bit more detail in a minute. You know, this isn't unusual for a new cannabis market to open up and to be subject to some litigation. I'd say actually what's a little bit surprising here is that the litigation, you know, didn't happen right away, that some of this litigation started, you know, 18 months, 2 years after MRTA was first formed. So, you know, one note there. And so just quick timeline, you know, some lawsuits filed, you know, March seems to be the heavy moment of a lot of litigation, initial draft regulations in June. And then obviously, as mentioned, the New York board meeting this past week got us adopted adult use regulations, and then preview of applications and application licensing opening up. Next slide, please. All right, so current number of medical organizations, 10 operational, the vertically integrated organizations. There's an 11th that via some court litigation settlement does have, there's an 11th RO hanging out there. And I will say there's one more court case working its way through. So plus or minus another one that might be on the horizon. And then adult use, I assume is what everyone came here today. This is coming online now. We do expect applications to be opening. We now have a date, October 4th, 10 a.m. Everyone get excited. Applications will be opening for new medical applications as well as adult use. And then just a reminder, I'm sure a lot of people are card licensees themselves or have questions about that program. What are the implications? So we'll touch on that a little bit, but just to kind of give an update as of right now, still OCM is enjoined from processing, is joined as in prohibited from processing anything related to any sort of provisional cards. Notably, there is a hearing coming up on tomorrow, Friday, just going to be attorneys only, the judge has stated, so no need to travel or show up in person. It's going to be just an attorney virtual conference, and that check-in is at 10 a.m. and I'm hopeful we'll get a lot more information at that check-in as to where things stand with the card program and the card litigation. Next slide. All right, and these slides for your reference, I'm going to breeze through them because I know everyone wants to know what's happening today, not historically, but we will email this out after the fact. So everyone who has signed up will get a copy of these, but just a reminder of the timeline here and where things stand. And as I mentioned, medical applications will open on October 4th for new registered organizations. All right, next slide. And then just kind of a reminder, I always like to remind people of cannabinoid hemp and, what's going on there as well. So we do have open applications for retail, distributor, processor, kind of temporary retail licenses there, medical licensing opening October 4th, and then adult use, just letting everybody know that the final rules were adopted at the board meeting on September 12th, adopted, not yet effective. So these still need to be published in the register before they're effective. Usually takes about 2 to 3 weeks after a board meeting till they're effective. But essentially once they've been adopted by the board, we can count those as effective. And then just a reminder, cultivation, processing, distributing, microbusiness, and retail, adult use applications will be opening October 4th at 8 a.m. Next slide. All right, 2 minutes on litigation, see if I can do it that quickly. So just a reminder, the Variscite case, which impacted card, limiting the number of regions and where card licensees can be awarded, which geographic region, essentially that happened in September. That was probably the first litigation we saw related to New York cannabis, and that since has been resolved via settlement. All right, next one. Then we do have Coalition for Access to Regulated and Safe Cannabis. This one is still hanging out there. This is an open item. So just I'm reminding everyone, while a lot of people have been focused on the current Fiore card litigation, this one still does exist and is still out there waiting to be fully briefed, fully heard, and waiting for the ultimate resolution in this lawsuit. Next one. Almost done, 2 more. And then, what is being talked about is the card litigation of Fiore, just as I mentioned, right now currently subject to that permanent injunction, no processing of any provisional or waiting to hear applicants for card. And then just a reminder, there is a hearing tomorrow at 10 a.m. just for judges only, but hopefully we'll get more information after that hearing. All right, next slide. Then hemp, just a reminder, there is the emergency intoxicating hemp regulations that OCM put out that is also subject to litigation. And there's actually a hearing today at 2:15 related to that, but that does impact, the rest of the segment of hemp in the market. Next slide. All right, got through where things stand. Now let's talk about the exciting stuff. I'm going to hand it over to Brandon to get into a lot more detail.
All right, thanks, Michelle. Okay, so timing is important here. So the additional RO round will begin on October 4th, and then the rest of the adult use licenses will also open on October 4th. It's a 60-day period. The resolutions passed by the board at the meeting seem to indicate that if you identify a property with your with your retail application that you will be reviewed after the 30th day, and then non-property applications will be reviewed after the 60-day period. So it seems to suggest that if you have control over a property, still pending information in terms of what exactly that means, then you will get a initial review or a priority review. So keep that in mind. Next slide, please. This is the vertical integration is prohibited. This is what we've known all along. There's two-tiered system: supply tier, cultivators, processors, distributors, cooperatives, micro businesses, ROs, and then the retailer tier, which is retail dispensaries, delivery, consumption sites. Then of course there's lab and ROs, the medicals, and then there's the ROD, which is the distribution, and the RO, there's the RO distribution, and then the RO dispensing, which is two different categories of the RO licenses that you can get an RO for, and then apply for these additional RO licenses. So the cross ownership prohibition is still in place, which basically says that you can't have a direct or indirect interest across tiers. And then, a retailer in New York cannot have a direct or indirect interest in a non-retailer licensee outside of New York. So that out-of-state prohibition still is in place. And there's no materiality threshold there. It's any interest, which is a little bit different than what we saw with the lab licensees, where the materiality threshold was at 10%. So we're still going to be working with those tier restrictions, including the out-of-state one. Next slide, please. In terms of eligibility to apply, applicants have to be 21 plus if it's an individual, and then U.S. citizens or individually admitted permanent residents in the U.S. What you'll see throughout this presentation is a lot of screenshots that we pulled from the sample application that the OCM posted on their website. And I highly recommend that anybody who's interested in applying for any of these licenses familiarize himself with this document. Although it's likely that there's going to be changes between now and the 4th, but I think that this will provide everyone with a pretty good idea about what they should expect if they're interested in applying for any of these applications. Next slide, please. So this is a big question that everybody wants to know. What are the total number of licenses? Obviously, we know that there are no caps at the local level. They can only, the municipalities can only do time, place, and manner restrictions. But of course, you are dealing with the state and potentially local setback requirements. And we don't have any official word on from the OCM in terms of how many total state licenses will be issued. If you recall, with the CAURD program, they came out with an additional number that they expected to give out, and then that number changed. So we'll wait and see what the total number is, and hopefully that will come out with some guidance and FAQs, which we're expecting in the next days/week. Next slide, please. So the application format is very similar to the application format for the CAURD licensees. You have to create an account in the New York's Business Express portal, and then you have a universal application that's going to be tailored to each license type. So you go in and you register for the account, and then create a contact information and check that email, and then obviously, as I just said, review the regulations, guidance, and FAQs. Keep in mind that there's going to be 3 separate portals. One is for the general application, one is going to be for your TPIs, And the third one is going to be if you're applying as a social and economic equity applicant, there's going to be a portal for that application as well. And so depending on what you're trying to do and how you're applying, you will be completing all of those, at least two of them, with the TPI and the general application. So this is just kind of an overview of the application materials. It's not narrative focused, which you do see in some states. It's more about like your corporate documents, your true parties of interest, your cannabis interests in other states, what's your ownership, a continuity and plan in case the business runs out of money, a signed certification of compliance, OCM training completion if that's happened. Again, there's no requirement that you apply with the location, but if you do apply with the location, then you're supposed to provide certain information. And then if you are applying as a social and economic equity applicant, then evidence of that qualification. So you'll have to submit documentation to show that you meet the state's qualifications for a C designation. So this is, again, screenshot from the draft application that the OCM published, and you can kind of see, what the format is. So, just like yes, no boxes, and then, if a yes, you're going to upload the agreements. And that's kind of what you're going to have to do throughout. So it's, a bit of a nuanced application, and there's going to be a lot of details. And so it's good to, be able to go through it and then, have all of the materials that you need to upload as you answer yes or no to these questions. Again, this is just pulled from the application. This is specific to trade secrets. So, if you're going to be submitting information on the application that you deem to be a trade secret, the application provides this area where you can indicate which parts of the application are deemed a trade secret. And then, you would get protection from disclosure in the event that somebody submits a request for a public record request on the applications, in the event that the OCM deems that, what you're saying is a trade secret actually qualifies as a trade secret. So just something to keep in mind. All right, I'm going to read through this entire slide verbatim, so buckle your seatbelts. This is just application material and fees for the Cultivator. Cultivator tiers 1 through 5. Tier 5 is the biggest, capped out at 100. And then, of course, you're deciding between, outdoor, mixed light, indoor, or combo. And you can just decide what you're applying for and designate as such on the application, and then you will pay these fees upon submission of the application, and then annually to renew the license. So no need to go into too much detail here. We can go to the next slide. This is application fees and materials for a processor. So there's a little bit more information that's required for the processor. If there's a location that you're identifying, then they're going to be asking for a letter from the fire marshal or other engineers. They want to know information about what type of processing activity you are going to be doing, which is basically separated into extracting, infusing, blending, and packaging, labeling, and branding, infusing and blending, packaging, labeling, and basically doing like white label agreements. And then you can see that there's an associated fee based on the type of activity, and and then a separate fee if you're a tier 1 or tier 2 cultivator, and then you're also applying to do packaging in terms of like branding and labeling. So just some differences there in sort of the different type of materials that you're going to be needed for different licenses, or the processor specifically, and then cost or fees. Next slide. so this is the distributor license. You know, if you're going to disclose a location, then you need to provide an inventory tracking system. Obviously, that's not the case if you're not going to provide a location. $7,000 per licensed premise. And then again, you see this is reduced fee if it's if you're applying, if you have a processor license and you're also applying for the distributor license. The fee is 2,500 as opposed to the 7,000. Next slide, please. Retail dispensary, again, you know, emphasize that there's an indication that you'll get a priority review if you submit your license application with a property. If you do submit with a property, then you see some of the information that you will have to submit as part of the application: notice to the municipality, the address of the entrance, certificate of authority, you know, list of schools and houses of worship within the buffer zone, the retailers within 1,000 or 2,000 feet, depending on the size of the municipality, management staff if they're hired, any type of community engagement efforts. And then you can see the license fee is $7K, and then the license fee if you're doing a limited consumption facility is $10K. Of course, we're waiting on more information. There hasn't been an announcement on the delivery and the social consumption licenses. We expect for that to come out soon, but for now, we don't have information on those two additional license types. This is the overview of the micro business license. This is the only license outside of the registered organization license that allows for a you know, vertical integration. So you have to engage in processing, distribution, or at least one of the, you know, or processing and distribution, and must engage in cultivation in at least one of the additional activities: processing, distribution, or retail sales. So there is a mandatory cultivation component to the micro business license. And then you can see the three cultivation tiers, and depending on whether the type of lighting you're doing, indoor, mixed light, or outdoor. And then, you know, you can see in the furthest box what the micro business can do in terms of, you know, selling to a processor, selling to a distributor, selling cannabis products, selling delivery, and then sending to the processor, and then opening up a consumption facility. So you can do it all, but it's limited, and that may be of interest to some. So this is just more on the micro business. It will ask you what activity in addition to cultivation you plan to participate in, and it's going to be a $4,500 fee for the micro business. And then you can just see, you know, on the right here, what the draft application looks like with respect to questions for the micro business. All right. With that, I'll turn it over to Elliot to talk about raising capital for New York applicants.
Hey everybody, it's Elliot here. So there's kind of like two big components to raising capital. Obviously, one is to get your financing and your capital to build out your facility, get your license, all that good stuff. The other is strategic and kind of trying to meet one of these kind of SEE buckets that are in the application. So I see a bunch of questions around this. I'll just take like a moment to here kind of just talk about the social equity economic applicants in general. There's a lot of questions around the priority there, and to be clear, we're actually kind of questioning what the priority is itself. And for those unfamiliar, the MRTA and the regulations, the applications are going to give priority to certain social equity groups, in particular those from communities disproportionately impacted by the war on drugs, disabled veterans, and distressed farmers. And so those are the groups that are going to get, according to the materials, priority review. In addition, they also get 50% off the fees that are stated in the regulations. What I didn't include in that group were the minority and women-owned businesses. And it seems that the only benefit those groups will get, at least currently based on what we've seen, is the discount on the fees, the 50%. They are not included in the same group that's going to get the priority review. Now, I'm not clear what priority review means, given the fact that they're gonna the OCM has already said they're going to take 30 to 60 days to review the applications. So priority review maybe means that you'll just get notified first of your issuance of a license. This is something we're going to keep track of going forward. And we'll provide more details. Sorry, Michelle, go ahead.
No, just to cut you off there. And then there's been a couple of questions about, do we have the CDI map? We don't right now. Right now we have a little bit of information in the C report. So there was an actual report discussing, the priority communities and that, and within that C report, there is a CDI map for Manhattan, but we are waiting for what we anticipate will be kind of like a static map that does go over the incomes throughout the entire New York State, just not New York City. And then hopefully one day that will transition into some type of, GIS map that's, a live living document, because, this is hopefully one of many licensing rounds in New York. So we're going to need those zip codes and that income information to get updated. But in the meantime, to answer the direct question, right now we don't have a CDI map, but hopefully we'll have it soon. Hopefully whenever they post the FAQs and the guidance, hopefully we get that map. Because obviously if everyone's trying to apply in 3 weeks, we need to know which zip codes people get that extra priority, kind of whatever that means. Seems like it'll be a good thing.
All right, so back to the show here. So on the slide deck here is true parties of interest. For those that have been reading the regs, this topic has been discussed ad nauseum from all sorts of angles here. So the important thing to know about true parties of interest, these people that are true parties of interest but not passive investors, which we'll get to in the next slide, have to be disclosed and vetted by the OCM as part of the application. As Brandon mentioned, they'll be going through a separate portal for that. Can you go back to the prior slide? Sorry. So and as you'll see from this list on what is a TPI, it's pretty exclusive. Pretty inclusive. So it pretty much captures pretty much everyone in your corporate structure. The term financial interest that's used in the 5th bullet there, that's means anyone that has a future right of ownership. So even if you have no ownership today, but hold a warrant or some convertible debt, that potentially captures you as a TPI. So in addition to being disclosed and vetted by the OCM, TPIs are subject to pretty much the same vertical and cross-tier prohibitions as the licensees. And so, as people out there are looking to gain their, get their investors, that's an important thing for them to know, especially those looking to enter on the retail side in New York. Everyone's aware, or at least is now going to be aware, that there is this out-of-state vertical prohibition, meaning that if you have an interest in a New York retail license of any kind, you cannot have an interest out of state in the cultivation processing license, even if it's not a New York license. So, all the vertically integrated operators outside of New York can have an interest in a retail dispensary within New York. Just in case this gets asked, the inverse is not necessarily true, meaning if you have an interest in a New York cultivation processing license, you can have an interest in an out-of-state retail license. So it doesn't work both ways. Whether or not that remains in place or gets litigated at some point, that's something we'll see. So again, looking at this list, it's pretty inclusive. As you can see in the 3rd bullet point there, it actually goes up and down the corporate structure. And so, pretty much anyone is going to be, with the ownership interest is going to be captured as a TPI. The 4th bullet point there is also important. This is kind of a catch-all for TPIs. This is the famed 10%, 50%, 250K rule. So pretty much any person that crosses those thresholds is going to be a TPI. So that applies to even us, Vicente, as a law firm. So if we get $250,000 in legal fees from an applicant or licensee, we're going to have to be disclosed as a TPI for that applicant. What's important here to note too, in this the 10, 50, 50%, 250K rule, is it also applies to debt. In particular, the definition, the regulations clearly state that principal repayments not included in the threshold, but that means that interest payments are. So if you have a loan out there and the interest payments in that loan exceed 250K in a given year, the lender is going to have to be a TPI, even if the lender doesn't have control and all the other good stuff that the regulations are trying to capture. Next slide. So an easier way to look at TPIs is what's excluded from the TPI definition. So on this slide, you can see what they've clearly delineated as not being a TPI. So this is kind of important when you're structuring your arrangements with, you know, your vendors, third-party service providers, consultants, people that are going to provide goods and services. You should all look at this and make sure that you're drafting your agreements compliantly here. Again, you can see in some of these bullet points, there's the 10, 50 versus 250K thresholds. So, you know, no matter what, if you cross those, you're going to be TPI, no matter how you constructed your agreements. And also note too, that the regulations clearly state that they will stack agreements. So if you have agreements with a group of affiliates, they're going to stack those all together to see if you cross the thresholds. You know, we've worked on these agreements in other states and have structured them, you know, different IP holding entities, things like that. But if they're all affiliated, they're going to be stacked together to see if they cross the thresholds. Next slide, please. All right, so the regulations were drafted in a way that I didn't think made sense, but what they did was they've created a subset of TPIs that are excluded from disclosure and vetting, and then also have certain additional allowances under the regs. But as you can see in the bolded part there, it says passive investors means a person that is a true party of interest, but then also has these other aspects to it. And so, oh, it's not on this slide, it's on the next one. But so these are, oh, sorry, it is on the slide. So the ownership thresholds here are 5% for a publicly traded company, 10% for a privately held ROD or micro business, or 20% for any other entity. So essentially, for those out there getting their equity financing, this means if you're a private company, which most of the applicants will be, if you have somebody that falls under the 20% threshold, they'll be considered a passive investor so long as they don't have control and undue influence, which is defined in the regulations. And this means the big benefit here is they won't have to be disclosed and vetted. And when I say vetted, that means that the OCM will have the right to conduct a criminal background check on the entity and the principles behind it. You know, for those in the cannabis industry, that's kind of the normal course of doing business. But for those that are new and entering that, that's something that, you know, they should be aware of and may discourage some. If you look at the last bullet here, they do look at future, you know, equity fully diluted counts. So for those thinking that there are potentially ways to you know, for lack of a better word, game the percentages here, the OCM is kind of privy to all that and what they've seen in other states and have regulated around it. So it's going to be tough to try to sneak someone in under these thresholds when they, you know, they truly aren't. Next slide, please. Again, yeah, so these are all the kind of the prongs in what you might need to include. Again, all the non-passive investor TPIs need to be disclosed, and the passive investors don't need to be disclosed unless they cross these thresholds. Next slide. And so here's kind of the current state of play of what we are, how we have look in here today. There's 24 operational card licenses. There are AUCCs and AUCPs out there. There are currently no distribution licenses. All the AUCCs and AUCPs can distribute. So that's how that tier is taken care of. The MRTA has these other 8 adult use license types, as Brandon mentioned. Most of these are coming online for the next application round, but there are certain ones that haven't been included, in particular the delivery and was it the nursery license? And then again, no local licensing regulations except for time, place, and manner.
Nursery and on-site consumption.
There you go. Thanks.
Going
Thanks,
back
Michelle.
on mute.
Next slide. And again, I know Brandon touched on this, but as I mentioned earlier too, you know, the big thing here to know about being designated as a TPI is that you're going to be subject to the cross ownership prohibition, meaning, you know, you can't cross the tiers in New York. So if you're a TPI on the retail side, you generally have to stay on the retail side, and the retail side is delivery, on-prem consumption, and the retail dispensaries. If you're on the production side, you have to stay on the production side, and the production side includes cultivation, processing, and distribution. You know, there are the ROD, ROND licenses, and the prohibitions there are somewhat all over the place. And so that's something if you're interested about, you can come ask us and we can give you the exact kind of lay of the land on that. Next slide, please. Again, so these are some of the horizontal prohibitions too. So even though you know there's the cross tier prohibition, but even if you're staying on the retail side, there are certain limitations you can have. And for example, you know, if you're a TPI and a cultivator, you can only be a TPI in one cultivator. You can, if you're on the retail side as a TPI, you can be a TPI in up to 3 retail licenses, and the like, as you can see here. So as I think many are aware, you know, there's been a lot of feedback on the New York regulations around these points, and the fact that these prohibitions will limit the ability for licensees and applicants to obtain investments. And you know, New York has been adamant. You know, our firm, a lot of other firms, a lot of people on the call here have put in comments to try to change some of these. Unfortunately, the OCM has really stuck to their guns on creating the 2-tier market. So having the cross tier, these horizontal prohibitions, and you know, as much as everyone commented, they've remained in place generally as they were in the first round of regulations. Next slide. I think we're getting close to questions here. Debt financing. So again, yeah, as I mentioned, debt financings. There's this definition of financier. But just given all the regulations, to keep it simple, in order to qualify as a financier, you have to be your kind of standard lender, with your typical covenants, but without covenants that go beyond what you typically see in a loan agreement. Otherwise, you will be captured as a TPI with control. And then, as I mentioned earlier, make sure that you don't cross the 250K threshold, which includes interest repayment. So you might have to structure your debt in a certain way where the interest doesn't exceed that, and the like. Next slide. All right. So yeah, I'll turn it back over to Anne, who I think has been sifting through the questions, and we'll fire some of her own and some of those at the team here.
Sounds good. Thanks so much, Elliot and Brendan and Michelle. A lot of great content there. Now we have a lot of great questions. Let's run through them. What I will do is that I'll run through the Q&A, the questions posted in the Q&A first. And then I've also been tracking questions that have been posted in the chat. So thank you so much for that. First question is from Devin R. When will the conditional processor cultivators be required to adhere to the TPI regs for the brands they are white labeling for? Who wants to take that one?
Any takers?
So I think as Brandon mentioned, there's going to be kind of a provisional license that you'll get after you apply, and then there'll be a final licensure process. And our understanding is that at the final licensure process, the OCM is going to request kind of all your agreements with your partners, and that'll include the white labeling agreements with the brands. Now, this kind of raises another point. The regulations also make clear that if you're going to be a licensed processor in New York and you're going to white label for another brand, that brand either has to be another licensed processor in New York itself or a TPI on your license. You're limited to white labeling for just those parties. So that's something to keep in mind for those processors looking to white label brands here in New York.
Okay, thank you, Elliot. Next question. If ROs may have cross-tier interests in other states, may micro businesses, TPIs also have retail interests outside of New York? Who wants to take that one?
That's a good question. I would assume, I haven't looked in detailed part of the regs, but I would assume since micro business is allowed to be vertically integrated here in New York, that they wouldn't be prohibited from having vertically integrated or cross-tier assets out of state. But I'll take a closer look in that one.
All right, thank you. Next question from Aaron S. In the context of TPI disclosures, Elliot, you're getting hammered. Are there any potential loopholes or nuances to be aware when a private investor is involved? I'm keen to understand any intricacies that might be relevant in such scenarios. So just any gotchas that you've seen happen.
Loopholes, we won't disclose any of our secret sauce loopholes here. No, I'm kidding. In case there's any regulators on there.
Yeah, I was like, in case anyone's watching, there are none. Follow the rules.
So what I'll say here is that, you know, the New York has really emphasized the cross tier and vertical prohibitions, and is really leaning heavily on the TPI definitions and disclosures. That's in part why they have a separate TPI portal, because that's something they're gonna be tracking throughout, and it is an obligation on the licensee to have their TPIs updated as they change as you go along, including, you know, potentially removing people as TPIs once they fall below the thresholds. You know, we have been working with the conditional and the card licenses, and I will say that the OCM, you know, has been taking a close look at the agreements, including for control elements and things of the like. And so, you know, as a law firm, you know, we tell you to be as compliant as you can and disclose, you know, what's asked for, and that's kind of the best approach that we recommend.
All right, thank you. Next question from John. Oh, John Sullivan. John, if a person has an interest in an out-of-state retailer, can they apply for and win a New York micro business license? So lots of micro questions right now.
Oh, so I think that's similar to the first question, and I think
Yeah.
that would be okay, but don't hold me to that. I'll double check the regs there and get back to these particular asks.
Sounds
It appears
good.
that the retail's on the supply side, or the micro business is on the supply side of the tiers with the cultivation processing. Although it does have a retail element to it, so it's a bit unknown. But
Yeah, so I think you're okay then, because if the retail's out of state, then New York really doesn't care kind of what you're retailing out of state.
Got it. Good to know. Next question from Clifford F. Wishful thinking, maybe. Is there a minimum separation between dispensaries? Does that go away after December 31st?
the
There's a
dispensary
setup
setback
requirement?
Yeah.
there's still the dispensary setback
distancing.
requirements are still in place. The 1,000 and 2,000.
Yeah, there's
I
no
think-
time period expiration date, unfortunately.
Yeah. Sorry, Clifford.
Yeah.
I guess one
That might
thing
be
to note about these regulations, which was if you weren't watching the board meeting, so, you know, there weren't changes really from the last draft to the final draft, although please take a close look to confirm that. But, you know, they did say that they're going to be OCM and the board will be interested in still hearing all the public comment and potentially, you know, starting to work through some regulatory changes. So I would say, you know, this is the life we're living under for now, but there might be future changes to regulation. So while there's no time period set expiration, you know, I think if the market evolves a certain way, there's that opportunity to go back in and change the regulations.
Yeah, absolutely. It's always good to comment, to have it on record. All right, next question from Dylan M. Can a C app or social equity applicant apply for an RO license, also get the reduced fees or any priority? Brandon, I don't know if you want to take that one.
Yeah.
Oh, go ahead, Michelle.
Yeah, I believe there are reduced fees if you qualify. And I know that was one of the priorities in MRTA to having registered organizations be more diverse. I believe there are reduced fees as well.
All right, thank you. Next question from Bruce. Would appreciate you speaking about what control over a retail space means or might mean.
In terms of the 30-day priority, and that's for retail and micro business. That's as far as my clarity can go.
So I'm not sure if the question's asking about control over the property. So for control of the property, you know, based on the application mockup, you're gonna have to submit either a lease or an LOI with the landlord that shows that you have rights to get that space if you're licensed.
And that's what we're thinking gets you that 30-day priority for retail and micro business. But as we've said a couple of times now, I mean, we know what we know based upon what's been released, but we're expecting a whole ton more information to come out. And hopefully some of these will be answered in OCM's FAQs and guidance documents.
Yeah, and if the question was about kind of control governance wise, in the regulations there is a definition of sole control, which is worthwhile to take a look at, and it delineates certain things that the people that are supposed to have control over license type need to be able to do without others' consent and vetoes.
Thank you. Next question from Gabe C. In the regulations, there's a section that says adult use cultivator transition. as $19,000. As an AUCC wanting to transition to a regular license, would we be required to only pay this fee, or do we pay the fee for whatever tier we want to participate in, or is it both?
I'd have to take
So,
a closer look on fees, but I believe you'd be paying the license for the tier you're going into.
and generally speaking, just so people are clear, there is an application fee that you pay when you submit your application, and then there's going to be a separate license fee that you pay upon issuance of your license.
Yeah. Next question from Eddie. Actually, if Vicente team, I can actually take this one. Does the inventory tracking system specifically have to be BioTrack, or can it be a separate WMS that later integrates with New York BioTrack? So it does not have to, your inventory tracking system does not have to be BioTrack. BioTrack is a selected track and trace model that New York State has chosen just for the traceability component, but any inventory tracking system and point of sale system that adheres to the guidelines for the integration, it needs to get pre-approved by New York State, but it does not have to be BioTrack. Next question from Adrian A. I'm an applicant for a card license that has yet to be approved. What is the deal with those applications now? Can I apply on my own without pulling myself off the other application? Can I actually be on both licenses if they were granted? So this, I'm assuming, is a previous application, not a license.
Yeah, so unless one of you wanted to take it. You can have an interest in up to 3 retail stores. So depending on how you structure it, you can still wait to be hearing where card lands that program, waiting to hear back on that application and still apply for a new retail store. And so even the operational cards would be permitted to apply in this licensing round to get store 2 and 3.
Got it. Thank you, Michelle. Next question from Stephen F. Is there a pathway to a larger license type in the future for those that apply for a micro business now?
I mean,
There'll be a process to convert your license yeah. But I think, right now there's this license application window. So we're not sure if what the conversion process to change your license from one type to another will be in the future. And I think Michelle can maybe speak more to this, but there is the ability to apply for, if you already hold a license today, to apply for a different license type, with the understanding that you would, if needed, give up the current license that you have if there was a prohibition against owning both at the same time.
Got it. Next question from Benjamin B. Is the micro businesses including the ability to distill oils and other concentrated products?
Yeah, so as long as the processing license that the processing authorizations you have include those, then you'll be able to do that.
Great. Next question. Can you address what is meant by completing the OCM training on the application? Does anyone know that part?
I think the OCM has been providing a number of resources with respect to informational sessions and training. So if you complete one of those modules, I think that they give you a certification that you completed it, and then you would indicate as such on the application.
Okay, thank you. As a licensed compounding pharmacist, can I compound cannabis tinctures for sale? I don't
If
know
you
who wants to
obtain
take
the
that.
right cannabis license, but certainly just a compounding pharmacist license by itself does not get you the ability to operate in the cannabis space.
Got it. Next question from Bruce Sturman. In your collective opinion, how much do the TPI regulations limit potential investments in New York State? Not sure if anyone wants to answer
So
Elliot's not allowed to answer this one.
that.
So I think they have been limiting investment, in particular the vertical out-of-state prohibition, really because anyone who's invested in cannabis or willing to invest in cannabis has already, and they have all sorts of types of assets in various states. And so generally all the cannabis investors have vertical operations, whether or not within a single state, but just based on all their collective owning. So it has been a little bit of a chilling effect on the investors out there and the investor base. And this was something that, commenters to the regulations emphasized a lot, but again, the OCM stuck to their position.
Next question from Amy R. For AUCC, at what point do you need to disclose where you will be operating permanently?
I think it'll be during your transition application. If you do intend to move, I think they'll want to know that to make sure it's hitting all the setbacks and zoned correctly.
Okay, next question. Another question from Bruce. Is there an updated list of the unlicensed stores given the notice of violation updated since the initial 31 stores? Weren't we just talking about how there's how many
Yeah,
thousands
so
now?
yeah, so we'll talk about the illicit market here for a second. We've heard all sorts of numbers. I think some of the official reports had the illicit number of stores in Manhattan alone at 1,400. I know recently there has been this 8,000 figure that's out there. So, point is there are a ton of illicit stores in New York, in particular within the city. I live in Queens. There's like 5 within a stone's throw of my own apartment. And so that is a huge problem. We do expect there to be enforcement coming down the line. And as people have noted, there have been some limited enforcement actions. I laugh a little bit because I think, the number Bruce mentioned was 31, but I think the only ones I think I've heard of was like 11. And so, again, we're talking about thousands of illicit stores and only, a couple dozen at most have been shut down, and, have those stores reopened, probably almost all of them. So that is something that needs to be tackled, and needs to be tackled pretty quickly and efficiently in order to allow for the legal market.
And I will say there isn't a public list, and it's both OCM enforcement, some law enforcement, and tax bureau. And I'd say, there might be more enforcement going on that we know about, it's not publicly available, that list. I'm sure someone's done a FOIL, but they're not publishing this, especially as the cases work their way through.
Yeah.
I mean, there is a list on the OCM's website of the licensed retailers out there, the 24 that are currently operational, for those that want to make sure they're getting regulated products.
Yeah. I'm actually going to switch over to some of the questions that were posted in the chat because I do want to hit some of these. A question from Beth R. Do you have to be licensed to train as a third party in New York?
I believe there was a certification program for trainers by the OCM, or I might be getting that confused with Massachusetts, but I think generally speaking, if you're not going to go into a facility and touch the plant, you don't necessarily need to be licensed. And there's ways, obviously, if you looked at the definition of TPIs and the like, you can be a consultant, which, in my mind means potentially providing training services without, being a TPI and all that good stuff, or bad stuff, I guess.
Next question from Patricia D. How are communities disproportionately impacted determined? Michelle, I know that you did speak about this earlier about like a map hopefully getting published, but not sure if you want to add.
Yeah, I can drop a link to the C report, which goes into a lot more detail, as well as the actual definition from the regs and how it's calculated, but essentially it's income and arrest rates would be the punchline.
And can I just jump in here? So I think this questions have been asked a few times. The regulations include this no less than 30-day notice requirement before application periods are opened up. And so people have been questioning that the October 4th date, given that the CCP will happen on Tuesday. So, that was September 12th. 30 days from September 12th does not appear to be October 4th. And so, yes, to people that are asking, is there potential for litigation? You can always sue, as I learned in law school. But I do think, that particular notice period might lead to a lawsuit. Now, the OCM may lean on the fact that the October 4th date was actually disclosed in one of their earlier reply briefs related to the Fiore matter. So that might be kind of what they're pegging that October 4th date off of. But we'll see on that.
Got it. Thank you. Next question from Michelle M. At what point of the application do you have to prove funds available at all? Is there a scenario where you can get approved for the license and then raise funds?
There's no, I mean, at least the draft application doesn't have a funding requirement, so you don't have to show that you have any funds. I think that, you know, if you read the regs, it states that you'll do this application and then you'll get a provisional application, and then you'll have to go through a certain number of steps before you're approved for final licensure. And so that will involve like the, you know, the build out of the facility and really the expenditure of more capital. So you in short, yeah, you will be able to raise funds after you get a provisional license, or you know, really at any time. The state isn't requiring a certain amount of funds that we're aware of based on the information that's been submitted, that's been shown to us so far.
Got it. Thank you. Next question, I'm jumping back to the Q&A panel. Next question from Zachary K. If a bank provides a loan to an applicant once they've received their license, can the licensee pledge the license as security? And if so, would it make the bank a TPI? Good question.
Thanks.
Yeah, thanks. I think you know, my gut's gonna tell me no. I didn't see anything particular in the regulations that prohibited pledging the license. I think though, obviously, if you take ownership, you know, that's going to require a whole step of regulatory approvals. But it does seem like the regulations are trying to allow for your typical kind of secure loans with standard covenants that don't go beyond what you typically see outside of the cannabis industry.
All right. Next question. Let me see here. So I'm going to go through. Next question from KDR. Will cultivators and processors be able to self-distribute or get a distribution license?
They can.
You can, yeah.
Okay.
Beat you to it, Elliot.
Going through. Will SOPs be needed for the initial application? I believe that was no.
Unless you're applying for, I guess it's not SOPs, but if you're applying for an RO license, there's more of a narrative component.
Yeah.
Okay.
And just a quick point on the RO. So just I know there's some confusion here. So the registered organizations, if you're applying for that, that means you're starting on the medical side. The ROs can only service the medical population here in New York. Once you're up and operational, have all of your medical dispensaries open, that's 4 of them, then you can apply to become an ROD or ROND, and that means that you can then, you know, wholesale or have this co-located dispensaries on the adult use side. But if you're going to go the RO route, that means you're going to stick to medical for a time being, get all 4 of your stores open, and then finally, then you can then apply to convert over to adult use.
And pay the conversion fees.
Yeah. Okay, last I've got like 2 or 3 questions. Many of us are pending card licensees. The general license application allows you to import your card license number. Do we get priority based on our card number?
So I don't think you're going to get a priority based on your card number license. I think the applications will be reviewed on a rolling basis. And so, you know, we know that it's opening October 4th, hopefully without any lawsuits delaying that. And so I think the quicker you get your application completed, the quicker it'll be reviewed. I don't think they're going to sit there and wait for all the, you know, say card licensees to apply and then review them in order of the card number.
Follow-up question from, sorry, go ahead, Michelle.
No, I was just going to say, you know, we're the board members and members of OCM staff that were at the board meeting, I know pledged their support and their continued dedication to the card program. But beyond that, we haven't gotten much of a concrete update in either privately or publicly about how the opening of the application period on October 4th is going to impact either provisional or waiting applicants. So we're hopeful to get more information either in the form of an FAQ or possibly, as I mentioned, you know, an update tomorrow after the hearing, but a lot of speculation about cards reapplying and whether or not they get priority. You know, open questions about how you apply. Does it have to be the same team? Do you have to pay the $500? You know, notably the C priorities as they're identified are not identical one for one with the card eligibility requirements. So really wanting everyone to take a look who is a card within the card program, whether a provisional or applicant, take a look back at their team as compared to the C applicant priorities and kind of take a look at your team, see if it's an identical one for one reapplication or if you need to change anything to get additional points. But I guess we have a lot of the same questions you have, and we're hopeful we'll get some answers soon.
Yeah, and I guess like that answers Kevin Wright's question. We do recommend, well, do you recommend reapplying again under these rules, even though you're frozen in the card lawsuit and you have a card license?
Yeah, I mean, given that you can get up to 3 stores, you know, if you're financially able to reapply and spend that $500 on the application fee and any back end fees, we do recommend that, you know, kind of hedge the bets. And then if you're well capitalized and you get a bonus, you get 2 stores, you know, instead of just the one you were planning on, all the better. But it seems like given the unknowns and that October is going to be here very soon, I do think it's worth applying.
All right, I think that that puts us right at the top of the hour. Lots of really great questions, lots of great answers and content. If, yeah, as you can see here on the slide, if anyone has more questions or maybe they did not get their questions answered, feel free to reach out to the amazing Vicente team that you see here. If you need technology, point of sale that is compliant for dispensary operators, feel free to contact myself. And then anything else? I think that that's it. Vicente team, any closing words?
Just a flag, Elliot and I and another team member of ours will be at NECAN Albany, kind of talking about similar licensing boot camp. So if you really want to ask any of these in person or hear a lot of the same things again, we appreciate you stop by, say hi. But we'd love to keep chatting about this and appreciate everyone joining today's webinar. And you'll get the slides emailed after and a recording link on YouTube so you can watch this over and over to your heart's delight.